Hi everyone, and you're welcome to today's episode of your Lawyer's Corner with Mo. On today's episode, we'll be talking about the rights of consumers under the Federal Competition and Consumers Protect Act 2018. And with me in the studio to discuss this topic is no other person but my own boss, Mr. David Adebayo. Mr. David Adebayo, you are welcome to the show, sir.
Thank you very much.
I'm so delighted to have you on this show today.
Same here.
It's such a great honor.
It's a pleasure.
Now, let's go straight to the business of the day. Tell us about the statute and its essence.
All right. Thank you. Briefly, we are going to be talking about the, Federal Competition and Consumer Protection Act.
Okay.
Now, that's 2018. It was enacted 2018. And the essence of the statute is to protect the rights, to spell out and protect the rights of consumers, to provide, a level playing ground for competition, and to ensure the protection and promotion of the right standard and quality of goods and services, be it common charters in the market or professional services or even online services, and sometimes maybe even e-commerce. You're trading, you're sending things to people connect with you online, and then you send the product to them afterwards, and all of such things. So what this statute has done is to spell out, rules, standards, procedures, expectations, rights, obligations, duties, implications, consequences, remedies for instances where such, provisions are contravened. So it's not just a statute, but it's a statute that also goes ahead to provide solution or what we call legal remedies to whatever aberration that might have occurred along the line, so that at the end of the day, there's justice to all the parties. So it's not just for, yes, it is called consumer protection, but it also does justice even to the suppliers.
Okay.
Yeah. So, and then maybe I should just quickly add before we go on that you may be hearing me utter some statements or words such as the undertaking.
Okay.
When we say the undertaking under this Consumer Protection Act, what we are talking about is supplier, a manufacturer, a retailer, a distributor. So whoever is in the provisional side, that the side rendering the service or providing the goods, they are broadly categorized as the undertaking. So whether you're the supplier, you're the manufacturer, you're the warehouser, or you're the distributor, wholesaler,
Everybody.
retailer, on the side of those bringing the service to the consumer. While the second, or maybe the loudest word you're going to be hearing today is that of the consumer. The consumer obviously is the person making use, the end user of the product or service. So these are the core this, and then of course once I say the statute, basically we are talking about that Federal Competition and Consumers Protection Act 2018. And then if I say the commission, I mean the commission set up to enforce, that's the Consumer Protection Commission. So these are some of the basic words you are going to be hearing from time to time. So when we say the commission, that is what it means. And then maybe when I also say the industry regulator, so that could apply to, or that could mean, for instance, the NBA, which is the umbrella body of lawyers who, regulates the affairs, the standards, the ethics of a practice among lawyers. So, and then maybe for chartered accountants, for instance, we have the ICANN, the Institute of Chartered Accountants of Nigeria. So they take responsibility for the regulation, disciplinary measures, standards, professional, ethics, and all of those, which are made to be binding on their members. So you may also be hearing industry regulators in the course of
Wow. You have really done justice, more than justice,
Thank
to
you.
the definition of the business topic of the day. Now, who are the relevant parties under this theme?
Thank you. In the course of the brief introduction, I've mentioned the number of persons. I've mentioned a retailer. I've mentioned a wholesaler. I've mentioned a distributor. I've mentioned a manufacturer. I've also used a general word of a supplier.
Okay.
So a supplier can be a supplier of goods, can be a supplier of goods, services. So these are on one side, and then we have the consumer on the other side. We also have the regulatory, the umbrella body that enforces or takes responsibility for the implementation of this statute, which is the commission. So now we also have the industry regulators. So all these are the relevant parties when it comes to consumer protection in Nigeria.
Wow. Thank you, Mr. Adebayo. What are the rights of consumers under the statute? The rights.
All right. Let me start off by saying that this is a very broad topic.
No.
In fact, the rights are so broad and numerous. Based on the statute alone, you can on the fingers of one hand you can count 12, and there are even still much more. So, but basically, maybe what we just do is because of time, we just pick a few and see how far we are able to go with them. So, but in essence, the law has mandated. When you hear of a statute is not an optional thing. Once a statute says something, that thing becomes mandatory. So once a statute says you must do this, or that this person is entitled to this or that, then that thing becomes sacrosanct.
Sir, sorry to cut you short a bit. Somebody out there is wondering, what is a statute? What is this man saying?
Good.
Please tell us what a statute means.
A statute is a law made by the legislature. That's the government body that is responsible for making laws. For instance, we have the National Assembly. So any law made by the National Assembly, once you hear us mention something and we end it with act, capital ACT, then that is a law emanating from the National Assembly. When you hear us also quote another law, maybe you hear us say criminal law or criminal. So once you just hear such a thing and it's ending with law, then it means it is that of the state. When you hear a regulation, then it means it is a law that is made as a subsidiary. That's the main statute, the main written law has said, okay, this person can make rules and regulations to administer this aspect and this aspect for the purpose of proper execution of this law. So those ones are called regulations. They are like secondary. So if there's any contradiction between the regulation and the main statute, then the statute will prevail over the regulation.
You have gone to another realm again. Thank you so much. We are grateful for that explanation. Now, the rights. What are the rights of consumers under the statute?
Okay, let me start off by talking about the right to information. Plain, giving the information and making it plain and understandable. So the statute says that there's some goods that must come with some descriptions, that must come with some statements, that must come with some maybe how to use them, what to expect when you take them. For instance, maybe medicine. So you notice that they all come with manuals. The manual will state a lot of things about them. So it must be stated in plain and understandable language. The essence of that is that the end user should be able to understand it, even as a layman. Someone who just has a basic literacy, capacity should be able to understand, see the information on the product and be able to easily understand what you are saying about the product. If you are saying this thing cures headaches, cures stomach ache, cures this, cures that. Whoever is going to read that brief statement about the product should be able to readily understand. So it should be in plain, not highly technical statements. So, and that one is contained in section 114 of the Act. So, as I said earlier, it is mandatory. So, where the law prescribes that, and even where the usage of trade or trade convention or the industry practices suggest or mandate that you should provide such details and descriptions and information about a product, you are bound to produce them, to state them, and to state them in plain, unambiguous language. Okay, that is like the first one, just to introduce that. And then the second one, which I take to be very much of interest, is the second right, which is right to disclosure of price. There's this thing that is so common in our society, where you enter a shop or you enter into a supermarket, all the goods have been displayed and the prices are not
not there. Yeah.
So the prices are not there. So you go around, you have to be asking, how much is this? Then you go to the next, how much is that? How much is this? So what this law is saying is that whatever you are offering for sale in the overt market and in such a place has to be price tagged. You must add the price to it. At a glance, we should be able to know what the price is. Let me also go into online marketers.
I was about saying that as well.
So online marketers, we have seen a lot of instances where people will post maybe a property and say, this building is located in such a place. They tell you all sort of rosy things about it. And then they say, call for price. No, this law says no. This law says that you must state the price. And if you also notice, you will see that major real estate companies, the ones that are really, specialists in the field, if you read through their adverts, you always say at the end of the whole thing, you will see the price boldly embossed, written there. Because they are aware of all these things. As a matter of professional practice, they know it as a matter of professional practice. They also know it as a matter of industry practice. They also know it as a statutory practice, as something that the law mandates. So, in essence, we are saying, and these things apply to, it's not just for, the consumers to know these things. As a producer, as a retailer, as a wholesaler, as whatsoever position you occupy in the value chain, you must understand that these things apply so that you are able to respect and observe them. So it's not just for the consumers to know their rights. The suppliers also need to know the rights of the consumer so that you can meet up with those expectations. So in this case now, whatever you are offering for sale, let the price be clear, let the price be fair, let the price be, undiscriminative. So you cannot see me now because, maybe I look like, I look fresh. And then you think, this person should pay higher. So the price is supposed to have been fixed and displayed. So you display all your prices. So, and that is very important to do. And maybe I should also say at this point that your prices also should not be contradictory. Prices should not be contradictory. So we are talking about section 115 now of the Act. So don't let your prices be contradictory. If you are bringing once it is the same product, the price should be the same. So don't have a price here. Maybe you have several of that product. Let's say the product is vitamin C. Okay. And then you have maybe like 20 pieces of the same kind of vitamin C. So, and it's all of them are actually supposed to be of the same price. So don't mistakenly write 1,000 naira here. And then maybe before, maybe you have reviewed the price and you forgot, to erase or to effect the new price across board. So you now have some reading 1,000 and some are now reading 1,500 naira. So because there's implication, to that, which we are going to still come to later on in the course of the discussion. So price is mandatory. You must state the price of the goods you are selling. Not only goods, even services you are rendering. Wherever you are promoting, wherever you are displaying for patronage, wherever you are calling for people's interest on, you must provide the price. You must also make the price clear. And also, maybe, let me not forget that you must also do your price tagging in our national currency. So, and especially now, the government is already, looking to implement, to enforce that and to descend on whoever is advertising in Nigeria using foreign currency. So, wherever you are advertising in Nigeria has to be, advertised in our Naira. So, it is Naira. So, you attach Naira to it. So, whether it is school fees or wherever it is, you are a consultant, whatever amount you want to bill people on, make sure that your price tags are in Naira. And even if those products are imported, we have seen instances where maybe some foreign products, you still see some price tags on them. Ensure to remove those price tags and replace them with the Nigerian equivalent of such prices. So ensure that your prices are, domesticated. So
we sure still have a long way to go.
Yes, absolutely. And maybe let me go to number 4 on the list, which is that the consumer is entitled to be informed about the condition of the good, especially in respect of whether the good is brand new or fairly used. So the law mandates every undertaking. Don't forget what I said an undertaking is. An undertaking is whoever is occupying the role or the position of someone that is offering something to the other person. So whoever is offering something to another person is the undertaking. That's if you're offering a product or you're offering a service to the other party, you are the undertaking. So whatever the undertaking has for sale, for instance, you want to sell a car, you need to let it be clear. Or you want to sell a computer, a desktop computer, or even a phone, whatever it is you want to sell. We have seen so many instances where people buy foreign used phones, and all of that. So there are some phones that will look new, but they've already been used. There are some cars that will also look so new, but they've been used. So whatever the product is, you need to let the state or the condition of the good be clearly stated. Okay, if it is already used, mention it. If it is brand new, mention it. And these things have their advantages and disadvantages, but majorly advantages in the sense that if you are offering something for sale, if you have already stated it ab initio, that's from the beginning, in advance, that, see, this thing is fairly used. There are some aspects of the law that will come to your defense later on if the person having bought it begins to use it and he's now beginning to encounter some normal wear and tear and some reasonable, disrepair in the product. The law will support or defend you or help you to exculpate you. That's to justify you. To say that, this person was not selling a brand new product to you. This person already told you in advance that this was a fairly used product. So now you cannot hold him to the standard of a brand new product later on. So, but if the person wrongly gave the impression and clearly, and the buyer relied on that representation that the thing is new, or gave every reason and avenue for the buyer or the consumer in this case to believe that they were new, and justifiably so, to believe that the thing was actually new, then if the thing begins to malfunction as a fairly used or second-hand product, then the person will be able to challenge you successfully in court, seek redress in court, and the court will grant reliefs in favor of the consumer. In that case, so whenever the law is stipulating, rights or obligations, it is for all parties to take note of them and to observe them, so that the law that is supposed to support you does not turn against you to now begin to penalize you. So whatever you do, make sure you are on the positive side of the law. So let the law be on your side. Or maybe let me say you should be on the side of the law, so that the law can always help you. Yeah, so, and that's section 117. And let me also quickly add the next one, which is number 5, which is sales records. Sales records under the Act is, if you hear sales record, you'll be wondering what is it about. But basically what it's about is what we normally call receipts. Receipts. So, and what are the things about a receipt? What do you call a receipt? A receipt is a statement of the name of the undertaking, the person offering the thing, the person selling or giving the thing. So the name, the address, contacts, phone numbers, emails, all those things. If you even mention what you are into, okay, so you see on the average, if you look at the typical invoice you see when you go to buy things, so you will see a lot of details in there. You will see the name of the company, you see the phone number, the address, and then there's also a room for where they are going to write the name of the product. Okay, and how many pieces of that thing, at what price a piece, per unit, what's the unit price of each. So you must provide all those things in the sales record. So, and you tell us how many the person is buying, what is the total cost. Okay, the person will sign, you sign. So all these details must be provided and given to the consumer. And what of these things would do eventually is that at the end of the day, to serve as the evidence of what was agreed upon. There's a matter we are handling at the moment now that is related to this. Okay. Yes, and it's in fact squarely a consumer protection matter. One of the things we are hammering upon is the invoice. So because the invoice actually disclosed a whole lot of things about the undertaking, what the undertaking is offering, the things the client paid for. So the client paid for about 6 different items. Okay. And then they also stated the number of pieces or units per item. And then, okay, their own cost of labor and every other thing. So, and then the total price. That was also, okay, what is the total price agreed upon? What was the total amount paid by the consumer? So, at a glance, the sales records will show all these things. It will help us to see, okay, what actually transpired. That is the essence of this. So what the law, as I've said earlier, has done is to make things clear. The law wants everything to be well, clearly stated and well known to all parties, so that as people are coming into a transaction, there should be so much transparency, and then there should be evidence of what was agreed upon. Everything will not be subject to conjectures. What did we say? What did you not say? Or how many did you pay for? No, I paid for 5. No, I paid for 10. No, it was 3 you paid for. No. Once the sales records, in the form of a receipt is being tendered, it makes everything clear. You can see. So those aspects are already well sorted. So if it is now a matter of whether the thing met the purpose for which it was, acquired or paid for, or the transaction was held for, that is another aspect of the law. So, but for this, you need to make all these things clear, and it is a must. And there are also penalties for default, where you refuse or fail to do these things. And in fact, funny enough, we have something similar in the tenancy law, under the tenancy law of Lagos State, tenancy law of Lagos State 2011, which stipulates that every landlord must give notice, a receipt. Okay, a receipt. A receipt of payment, rent payment to the tenant. Failing which, there's a fine of 100,000 naira. Yes. So, and when you hear a fine, that's an offense. That makes it a criminal act. So it's a crime for you to collect rent and not issue a receipt, or maybe an agreement to stipulate or to state this. So it's similar to this too. So, in other words, these are central and fundamental rights of the consumer that must not be breached. You must not breach them, because once a statute makes provision, as I said earlier, it becomes mandatory, and you must respect such a right. So the consumer has to know that he has this right, and the undertaking needs to know that the consumer has this right, and then you quickly position yourself to make sure that you observe those things, so that you are able to say that you have fulfilled all righteousness, and then the consumer will not be able to, sue you or allege anything against you successfully in a court of law, so that you'll be home and dry. The next right is the right of a consumer to select suppliers.
Okay.
And this is of interest to me in particular. We have seen instances where someone will say, okay, if you buy this piece of land from me, you must buy blocks from me. So maybe the person buys blocks and sells blocks. So the land vendor.
This thing happened to me last year.
Good. So the vendor has other products that surround. So, and because they are the ones selling the land to you now, they're now saying, oh, okay, so this is an estate. This is that. And so if you buy this land from us, then all the supplies of your granite, your sand, everything you must buy from us. You must buy from this our immediate neighbor, or you must buy from our licensed or accredited agent or whatsoever agent, whatever you want to call them. The law says that you cannot mandate or force a consumer simply because they are buying this thing from you or patronizing you for this particular product or service. Then you are making it a condition that they must also as well, subscribe to the other things through you or from someone you are recommending. But one good thing about this statute is that it does not actually preclude you from advertising it to the client, to the consumer. You can say, oh, we also render this service. You can as well smartly say, okay, you will enjoy this discount from us. If you buy these things from us, if you buy that from us, if you buy all of these things from us, these are the things you will stand to enjoy. In fact, and everything is going to be so timely, everything is going to be so well customized. And if you need, post service support and whatsoever, we are all there for you. So you can convince people, you can whet people's appetite for your product, but you must not make it a condition, like holding them to ransom. That's what the law is trying to do here. So the law says that you cannot hold someone to ransom by saying that once you buy product A from me, then you have to buy product B from me or from my friend or from my agent or from my brother or from no. The law says that the consumer has the right to, whether or not, to buy any other product from you.
It's not by force.
It's not by force. And you cannot compel them.